Terrible moves to exclude such prejudicial graphics such as Wizard of Oz video clips and rockets blasting off.
Okay, we're on the record in pages 1 through 25 in case 831543. Since there's a difference between people being here in person versus being remotely from the court standpoint, that doesn't change appearances. But if anyone wants to do appearances today versus saying the same parties, same counsel from last week, we could do it either way. What would you like to do? Counsels for plaintiff, I'll ask you first.
Your Honor, Teddy Parker, Will Kemp, and Eric Griffin on behalf of plaintiffs. Please put on the record.
Okay, no worries. Real Water, would you like to make your appearances then, please?
Good morning, Your Honor. Joul Odou, Matthew Kaufman from Woodsmith and Berman on behalf of Real Water Inc. and AffinityLifestyles.com Inc.
Eric Freeman on behalf of Real Water, and Mark Love is on Blue Jeans.
Okay, on behalf of ETT/Terrible Herbst then, go ahead, please.
Good morning, Tomasik on behalf of Terrible Herbst, along with Valerie, Rojas, and February via Blue Jeans.
Okay, so right before we went on the record, was told, and like I said, people are more than welcome to appear remotely, but just want to find out, is there any accommodation being requested of the court, or are we moving forward as scheduled? And that would be a question to Terrible Herbst counsel.
Your Honor, if I may, we're filing an AV appearance right now if it hasn't come through already. But we're gonna, we worked out a plan to power through today, so we're not requesting accommodation today. But thank you.
Okay, no worries. So zone of pressing accommodation, then we'll get you started, okay? Based on the listing we went over Fridays, the order the court was intending to go, if any of those have been resolved in the intervening time period, just let the court know when we call it so we get you a nice clear record. So what we show first is document 683, which is Terrible Herbst motion lemonade 21 to exclude testimony Real Water marketed and sold by Terrible Herbst after December 2019. So that would be counsel for Terrible Herbst. Would you like to be heard? Which one of counsels for Terrible Herbst would be taking this one?
Valerie or Trevor?
Your Honor, may I appear?
Well, of course you can.
Okay, our AV, I haven't seen our AV come through yet, but it's on its way.
Counsel, you all are, it's an alternative course, it's an accommodation. Go ahead, please.
Thank you very much. Your Honor, I think you basically addressed this motion previously. Your Honor previously ruled that the 2020 coupon can come into evidence, which essentially indicates that Real Water is being sold after 2019, but the purpose of this motion is because, as we've stated repeatedly, Mr. Hunwardsen stopped drinking Real Water in 2019. There are no other plaintiffs who claim to have purchased from Terrible Herbst, and therefore any sales or marketing after 2019 would be irrelevant, and that's the basis of the motion, Your Honor.
Okay, Real Water, I did not see that you had a position on this. Is that correct?
Yes, Your Honor. Joul Odou for Real Water, that's correct.
Okay, since Real Water has no position, counsel for plaintiffs, would you like to respond? And yes, the court's aware of prior rulings with regards to the coupons and other things.
Right,
please.
Your Honor. Yeah, just briefly, last time I mentioned Shoshone, the policy consideration. Can I have Shoshone up? We off to a bad start?
Is it on dot, Tam? Yeah, we'll make sure. Just one sec, yeah. No worries, we're getting you to doc.
All right. So this is the Shoshone case. It's the landmark, Shoshone versus Coca-Cola. It's the landmark case, and it explains why product liability extends to distributors. And I mentioned it, but I just wanted to show it to the court directly. By placing their goods upon the market, the suppliers represent to the public that they're suitable to for packaging, advertising, otherwise, they do everything to induce that. So advertising is the underlying rationale, and they cite Prosser, the fall of the Citadel here. Most jurors aren't familiar with Prosser, I would think. So we just want to show advertising as an underlying theme in the case to kind of support the distributor liability proposition, because some of the jurors have this, they're just a distributor kind of idea. You know, they don't really understand the law of it. So that's the first reason we want the advertising. The second reason, counsel alluded to impeach the credibility of Mr. Walters, who says he never saw any advertising at any time, including but not limited to August, September of 20 when they admitted. So it's for two reasons. It's one, to give the jury an idea of the advertising, and two, to impeach the credibility of Walters. So for those reasons, we think the court should deny this motion consistent with its previous ruling. Thank you.
Okay, counsel, sorry, one real quick question, since it was brought up in this motion independently, right, that the time period makes a difference because of when Mr. Hunwardsen would have actually purchased real water based on the date of his injury, hospitalization, whatever phrasing you'd like to utilize. Do you wish to address that component? Because this motion does it a little bit different than the other one from a little different angle.
Well, he was hospitalized in September 2019. These still ads ran in August and September of the following year. So there's a year separation. But the still ads go to the central point raised in by Terrible Herbst that they never ran advertising at any time prior to Mr. Hunwardsen's hospitalization. They've submitted an affidavit of Mr. Walters. He's the Terrible Herbst Vice President of Purchasing, saying that they didn't run any, he never remembers any meetings with Real Water, that they didn't run any video ads for Real Water, that they didn't run any advertising at any time for Real Water. And we know that's flat out wrong because they've admitted that this August, September 2020 advertising. So it comes in to impeach his credibility on that point. And that's, I think, a major point in the case because, you know, like I already said, their point is, you know, we never did anything for Real Water at any time. And our point is that they ran this extensive video advertising campaign that documented the business plan and elsewhere. So that is the central credibility issue in the Terrible Herbst case, Your Honor. And that's why we think that these still ads are so important. Not that Mr. Hunwardsen saw them, but that it's solely a credibility issue. And their only evidence that the video ads didn't run is the memories of these people. In other words, they submitted an affidavit, Mr. Walters, saying, I don't remember them. And that is the proposition that they're using to attack both Mr. Hunwardsen's testimony that he saw video ads and the business plan establishing that there's video ads and other evidence of the video ads, such as when we call Anthony, last name's Randolph, to trial. So it's a big credibility issue, and that's why these still ads are important as to credibility. There's not going to be an argument made that Mr. Hunwardsen saw these still ads or that they induced him to drink the water prior to his injury. They're admitted for credibility.
Okay, thanks so much. Counsel, just want to make sure, because when we put the doc cam up, then we can't usually see the individuals' faces with regards to appearing remotely, which is perfectly fine. I just want to make sure that you still can hear everything that's going on in the courtroom. So can one of the counsel from Terrible Herbst just confirm that you can? I want to make sure you're not missing out on anything.
Yes, Your Honor, we can, except when counsel moves away from the podium. I missed a little part of that, but I think I got the gist of it.
Okay, no worries. So that is a friendly heads-up reminder. Is sometimes, I know people have a tendency like to walk. If you like to walk, we'll be glad to give you a pocket microphone. If not, can you just make sure you stay within basically arm's reach of a microphone so we can get you fully heard, and particularly when we have people remotely. Okay, I do appreciate it. Counsel for Terrible Herbst, you get last word on motion eliminating 21. Go ahead, please, if you like.
Yeah, just to clarify, Your Honor, counsel's statements about what Terrible Herbst witnesses said or didn't say is extremely overbroad. No witness has ever said no ads were ever run, and I think we'll get to that kind of detail and what words were used. But it appears he later corrected himself and said, and admitted that Mr. Walters said he did not recall any of these ads during particular years. But be that as it may, if it's coming in for impeachment, we're in deposition in this case. So he submitted a declaration.
Counsel, you said the word impeachment, then it paused for a second, and then you heard the word deposition. So if there were some words in between impeachment and deposition, would you mind repeating them, please?
Thank you, Your Honor. Yes, my point was that counsel indicated that it's relevant to impeachment. And I don't believe we're there yet. Mr. Walters has not testified in trial, has not testified in deposition, and provided a very specific declaration in response to the motion. So I don't think that the court should deem this automatically admissible for impeachment purposes until we get to that point. And so if that's the basis for any ruling, I would ask that that be deferred until we get to a point where Mr. Walters in fact needs to be impeached. And with that, I'll submit, Your Honor.
I appreciate it. And remember, the court has to look for motions based on how the motions are actually presented to the court and who presented them. So this motion, as presented to the court, was Terrible Herbst's motion, eliminate 21, to exclude the testimony regarding real water marketed and sold by Terrible Herbst after December 2019. The court needs to deny that motion and eliminate. With the way that motion eliminate is phrased, the court is not ruling on any automatic admission of evidence, because this motion eliminate was a request to exclude, and the court needs to deny the motion to exclude the testimony set forth consistent with the court's prior rulings and for the analysis presented in the opposition. Let's move forward then, please. The next one the court shows, as you all had said, document 670 was moot, and so the court did not rule on it, so we are now going to go to document 670 was Terrible Herbst's motion eliminate 13. We understand that it's not being requested to be heard because that was withdrawn. That's correct, Councilor Terrible Herbst, is it not? That's correct, is that right?
Yes, it is, Your Honor. It is withdrawn.
I appreciate it, thank you. Okay, so then we're going to go to document 659, please, which is Terrible Herbst's motion eliminating number 3, to exclude the Wizard of Oz video clips and other prejudicial graphics from being used during trial. Court doesn't have an inclination on this, so counsel, feel free to move forward, but I will tell you the court will have a question when I get general statements such as other prejudicial graphics without having some articulation of specifics. Then the court's going to have to ask, is there some specifics you want the court to address? But go ahead, please.
Good morning, Your Honor. Jan Tomasik for Terrible Herbst. Terrible's moves to exclude such prejudicial graphics such as Wizard of Oz video clips and rockets blasting off. There's no hydrazine. There's no evidence of hydrazine being found in the products sold by Terrible Herbst, and it would be improper to taint the jury from the outset by showing them video clips such as the one mentioned or shown on page 7 of our motion. As the video clip is, or as the screenshot is shown, this was played during the Gallagher trial, and there's 1, 2, and 3 steps. The first one, the date real water is first made, we believe that that graphic or illustration underneath there is improper. And going further as to 2 and 3, for example, number 3, the Eurofins tests have limited applicability, or none, actually no applicability to the product sold by Terrible Herbst. So quite frankly, we are aiming to avoid a backdoor introduction of evidence that has no relevance as well.
Okay, of course, got a couple of extra questions on the fact we get to the relevance aspect. So are you asking with regards to some of these clips that there's a clarification of to whom they apply to, or are you asking for their preclusion completely? And, okay, so that's question number 1. Go ahead, please.
We would ask for a preclusion completely because, like I said, it'll taint the jury from the outset, and some of these video clips are quite frankly prejudicial. There's other ways that plaintiffs can explain principles that they aim to introduce, such as degradation, for example. There's other ways in which they can do it.
I'm understanding your preference, so my next question is, what's the legal basis for preclusion? You said prejudicial, right?
Mm-hmm.
But obviously, there's a lot of things that come in, right?
So
what's,
we cited Waters as an example that making arguments visually is just as prejudicial and improper as making them orally. Here, for example, I mean, you have graphics and illustrations from a movie. Date real water is first made, and it, you have the Wicked Witch, doing things there. I mean, it just, the jury may be misled into thinking that real water on purpose was, tainting their product, and that's not the case.
which is going to get into part of appreciate it overlaps a lot of different motions, some of which I've already ruled on, some of which are still before me. from purpose of this motion, you can, thinking of, once again, put this in a trial format. When you said that last statement, right, that Real Water put something in intentionally, isn't there a stipulation that specifically sets forth, right? Didn't you all, right, unknowingly, inadvertently, whichever way, you know what I mean? Well, the final stipulation says what the final stipulation says, so
Unintentionally, Your Honor.
unintentionally,
Right,
thank you.
and
I
then-
said- I remember that word was going back and forth, so, but
That would.
how does that,
Yeah,
could I maybe finish my question to make sure you're correctly understanding it? No worries, thank you.
apologies.
No worries. Okay. So with that being the rubric, right, in the real life scenario,
Mhm.
and I appreciate there's other motions about whether that should even come in. We have to walk through that one, but for purposes of this motion, how would the jury have that perception that somebody did something intentionally?
Well, like I said, if these graphics are allowed, then the jury may be misled and think that that's the case based on such graphics. Now, as to the stipulation, I think the stipulation also, if that were the case, it would be, we would need to read that to the jury before plaintiff's opening statements.
Okay, I appreciate it, thank you so very much. Real Water, I don't see that you had a position on that one, on this one.
We do not, Your Honor, thank you.
Appreciate it, thank you. Then Counsel for Plaintiff, would you like to respond? And yours
Yes,
is
Your Honor.
document 802.
Yes, Your Honor, what we're trying to do is explain what I think is a very difficult concept, which is hydrazine degradation over a period of 2.5, 3 years under varying conditions. So we have 3 relevant time periods. 1, when they made the product, how much hydrazine was in the product when they made it and the people drink it. 2, how much hydrazine was in the concentrate when the FDA finally tested it in October of 2021, which was a year after batches that were made that are involved in this case. So there was some degradation. We don't know exactly how much. Dr. Najim's testified it could be up to a factor of 10. So that's the second time period. First one, consumption. Second one, when they measured the concentrate. And then the third time period is the UNFI testing, which are on retail bottles that sat in an unconditioned warehouse with temperatures up to 100, 110 degrees, which has an impact on degradation. So they found hydrazine in those bottles, but they found a minimal amount of hydrazine in those bottles. So the problem in the case is the experts for the defense, and specifically Dr. Possenbach is the toxicologist retained by Terrible Herbst, he takes the last measurement, the lowest, and he retroactively uses that amount to calculate, and he says, well, the plaintiffs couldn't have consumed much because there's very little here. All right, so he just skips over the entire process of degradation. There are other toxicologists. They have another toxicologist named Dr. S. And Dr. S, he uses the concentration levels from the FDA testing, a different point of the degradation continuum. So we have two different, their toxicology theories aren't consistent. I don't know which one they're going to call. But the primary point here is degradation is a very important issue in the case, and it is hard to explain. Now, counsel says pretty cavalierly that I can come up with other ways to explain degradation. Your Honor, we didn't just pop the Wizard of Oz out of our back pocket, okay? We went through lots of analogies. We started off with ice cream cones melting in deserts to try to show degradation. We had other analogies on evaporation. And so we finally focused on the Wizard of Oz just because the clip, and I'm sure the court's familiar with the clip. I have it up here if the court wants to see the exact clip. But Dorothy throws the water bucket on the Wicked Witch. Well, it's a wonderful clip. If you want to see
Can
it.
we go on mute for a second? Can I have Counsel Pro to, and can you put on some white noise, because I have a different question.
Okay.
And this is gonna be difficult because I have people remotely, but we're gonna put you on mute, but as long as I have one counsel from each of the parties, and ask questions, can we? Okay, thank you. The court was just asking a quick clarifying, and since I had one counsel from each of the parties, the court finds it's appropriate, and if anybody wishes to speak with our co-counsel, I'm sure you all are texting, emailing, or can address it, and it's not substantive to the court's ultimate ruling. Does anyone think it's substantive to the court's ultimate
I don't
ruling that you
think
want me to say it in open court? Ask the question, I just was making sure no one's putting themselves
No,
in
Your
a
Honor, and I
situation.
appreciate your consideration about my potential liability.
I was just making sure, somebody check the dates, okay.
Yeah.
Okay, go ahead, counsel.
So Your Honor, rather than show the clip, I'll show the slide. Jane, can we have the slide? So here's the slide. We show the clip to give them the idea, and then we show the slide. And so the first scene is the full Wicked Witch before there's any degradation. The second scene is partial degradation. She's slumped down. And the third scene is total degradation. So time of consumption, the date the real water is first made, that's 10 times FDA concentrate, up to 10 times, according to Dr. Najm. The FDA testing on October 21, that's partial degradation, and the Eurofins test 2 years afterwards, after they're in the warehouse, that's complete degradation. So we're just trying to show the jury why there's a difference in these concentration levels. Their opposition says that this is some kind of attempt to equate real water with Satanism. I don't see that. They say that there's some sort of witch's cauldron in this photo. I don't see the witch's cauldron. But, you know, we're not trying to equate real water with Satanism. They haven't even objected this, and I point out that this is an 84-year-old children's movie. I don't think it's generally equated with Satanism. And we're not trying to mislead people. They said we're misleading people on purpose. I don't see any misleading. I just see this as being the best possible analogy to explain an extremely difficult concept. And I thought that this allowed everybody in the first trial, to attorneys, judge, even the jury, to really understand what's a difficult concept right away. And so for that reason, we would oppose any attempt to limit us. You know, trial lawyers should be given free rein to use analogies to explain difficult concepts. And, you know, if counsel has some other analogy, he says there's other ways, you know, give it to me. You know, maybe it'll be better than this, but I can't find it. And so for that reason, Your Honor, we'd oppose the motion.
Counsel, you get last word, go ahead, please.
Can you bring that up again, Jim?
Your Honor, I don't have much to add, but if you look at this slide in their example, it highlights also, like I mentioned earlier, number 2 and 3. Plaintiffs sought a pre-admission of the Eurofins test, and I believe that was denied. And, you know, like I said earlier, the Eurofins testing, and it says in parentheses, retail bottle tests, all of those took place after. None of the bottles relate to Terrible Herbst. They were manufactured on a different bottling line. And so for those purposes, we would also request that in addition to such prejudicial graphics, we also request that, you know, the text that's directly above and below, it has to be explained better. I mean, this is going to mislead the jury and paint them from the outset.
I appreciate it. We're going to do white noise one more time and ask counsel please to come back and approach. One more time, please. Okay. With regard to document 659, Terrible Herbst motion eliminating number 3, what the court is inclined to do is, just so we can get some points of clarification, is to rule on that on Wednesday. And everyone already had a full opportunity to be heard, and so we're going to defer that one to Wednesday. That's document 659. Do appreciate it. Let's move on. Let's move on to document 655, plaintiff's motion eliminating number 16, to preclude defendants from arguing or inferring that violations of law, regulations are relevant to the compensatory or punitive liability of defendants. Counsels for plaintiffs, go ahead. What's left of that in light of where you are with your current claims and defenses before the court, please? Let me pause for one quick second. Did we make sure we unmuted?
Yes.
Okay,
it's
perfect.
unmuted, yeah.
No worries, I just wanted to make sure everyone could hear that. Go ahead, counsel. Feel free to proceed.
Your Honor, I don't believe there's much left to this one, but let me ask the court before I go into a protracted argument. originally, motion limine number 16 to preclude defendants from arguing or inferring that violations of law or regulations are relevant to the compensatory or punitive liability issues was a little more overwhelming in the beginning because the court had not made the decisions it made last week. Now that the court has made some of those decisions, I believe that the motion has been narrowed. My thought is certainly the court is familiar with Guinness versus Mapes. We've discussed that case several times now. I think it should become clear to the defendants that the compliance with federal or state regulations does not negate the appropriate analysis for the court under the consumer expectations test. And so it appears to me, and I searched their opposition, Your Honor, and I'm sure you did as well, but I didn't see any particular federal or state statute or regulation that they intend to use as a defense, even if it was a defense, but I don't see it referenced here. And so their opposition, I believe, is a non-opposition because they don't reference a single regulation, CFR, Nevada statute, anything in their opposition. They just suggest that they should be able to argue them. Well, they don't have an expert that will proffer such an argument at this point. Certainly there were no expert reports attached that indicate these particular statutes or regulations they would like to utilize as a defense. And so I consider it a non-defense, Your Honor. The consumer expectation test is taken, of course, from Stackowitz, which you're familiar with, the 1984 case. Your Honor, we cited the Ford Motor Company, the 1983 case. And then, again, Mr. Kemp has said this case name many times, but it's, of course, the seminal case, the 1966 Shoshone Coca-Cola case. All standing for the proposition that the consumer expectation test is what's used and applied here in Nevada. And the defendant's opposition, in my opinion, Your Honor, does nothing to defeat this motion.
Okay.
Your Honor, do you have any questions? I thought this one was pretty clear cut.
I don't. I really was going to hear what was left of this in light of all the prior hearings, but
Thank you, Your Honor.
thank you very much. Okay, council opposition, go ahead, please. Will Water, feel free to go first. Go ahead.
Joul Odou for Real Water, just very briefly, Your Honor. The motion is regrettably very, very vague. We opposed because we wanted to make sure that it wasn't going to, this motion was not going to be construed beyond Terrible Herbst. The motion makes several arguments about what they think Terrible Herbst's defense is going to be. We obviously are not involved in that dispute, but then there's a question if there's some type of unintended consequence that this is now going to preclude arguments about compliance with the manufacturer of Real Water. We've already heard that that is an issue in the case that plaintiffs intend to present. They intend to argue about this $200 test. They intend to argue about sending a message to water companies, that sort of thing. I don't want to spend a lot of time on this if I don't need to. I just want to make sure that there's not this unintended argument from plaintiffs that this is broader than the frame of the motion. Because then in their reply, they did cite some of these things, and so we want to make sure that we know what's in bounds and what's out of bounds, Your Honor.
Okay, seems to me I've got two ways of handling this. One, I can let counsel for plaintiffs, in light of your comments today, right, based on things that are in your opposition, so it's nothing new, give a clarification, and then give you a moment or two to respond, and then plaintiffs still will get last words. And Terrible Herbst, you'd have an opportunity afterwards as well, so that you actually know what you're responding to. Would that make sense to everybody?
It does for Real Water, Your Honor. We appreciate that.
Yes, Your Honor.
Okay, so Mr. Parker, can we clarify if we're talking about the sending the message, the $200 test, some other things other than the concept under MAPES about what actually the law is, which you can and cannot argue in now, because and once again, I appreciate the time these motions were done. There was different causes of action that are now currently set for trial, and could change between now and then as well, but so given the current rubric with the stipulation, the current rubric is straight products liability, can we clarify what actually plaintiff is seeking so that I can get a response from defense?
Your Honor, I'm concerned or confused by Mr. Odou's confusion. I thought the motion was pretty clear on what you could and could not do. Perhaps with the elimination of the negligence claims, perhaps there's some more specificity he would like to have for me. And so, in regard,
Are you preclude, okay, let me maybe ask a couple specific questions.
Go ahead.
Are you seeking to preclude anyone from taking a position as to, you all have informally called it the $200 test, right? Mr. Kemp made a reference to it. Are you seeking for them to preclude that should or should not be a basis for, whether it be the causation of Brody, whether it be the damages for all parties, whether it be Hunwardsen with regards to Terrible Herbst, or whether it be punitive damages? Are you seeking to preclude that?
No, in fact, we were the ones, our expert, as a matter of fact, Your Honor, I can't remember if it was our expert or Real Water's expert, but I believe it was our expert who commented on the cost of the test. But we figured out how inexpensive the test was, but it was also in part because the CDC has a list of known toxins, liver toxins, in this case hydrazine. That came through expert testimony as well. And so when we found that this list of toxins were available, and this test, which is very inexpensive, could have determined if any of those toxins were in the water, that was mentioned and discussed during the trial, the Gallagher trial. But what I took from Mr. Odou's comments, which is somewhat gleaned from the opposition, and then we responded to it in our reply, was the requirements under NRS 42 for punitive damages. And I'm assuming he's concerned that we will raise issues of the inexpensive nature of the test for purposes of preventing the introduction of toxins into drinking water as a way of supporting our punitive damage claim under NRS 42. But if you look at Real Water's opposition, in my opinion, cited cases that were distinguishable, and we distinguished them because those cases, in our opinion, went to this risk-benefit analysis, which again has been rejected by the Nevada Supreme Court. And that's under the Falk versus Kane Court. That's the case they cite, and we indicate how Ford Motor Company versus Trejo is where the Nevada Supreme Court rejected the risk-benefit test. So I don't believe that we're going to do something other than what we've said in our motion, how we distinguish the cases in our reply. The use of the $200 by way of an example of a test to weed out known liver toxins is, what I suspect they're going to argue is it wasn't an industry standard to do that type of test. And we're going to say when you're
Are you
introduced.
seeking to preclude them from saying that?
Listen, they can say that if they want to, Your Honor. I don't think,
Okay.
Problem solved.
Okay,
I
so
don't
that's
think,
that one.
they said it the last time.
Okay, like I said, I'm just trying to appreciate why people do motions, because you never
Right.
necessarily know by the time you actually hear them what's truly left, and people like things broader, and you know what I mean? Then things get narrowed. Okay, so that issue is taken care of. So then the next one that was raised was realistically with regards to the punitive damages responses, right? That somehow, are you asking them to be precluded from saying that they complied with applicable laws with regards just in general? A difference between them utilizing it as a defense versus utilizing them to say somehow that means there's not punitive damages and there's not compensatory damages. Realistically, are you trying to eliminate their defenses?
Okay, so I'm going to use the $200 one more time as an example. Your Honor.
Appreciate it, thanks so much.
Real Water can't come to trial through an expert or anyone else and say that there was a regulation that said that they did not have to test. I'm looking at the converse of it now.
Terrible Herbst has contended multiple times, and I'm not sure if they still are, but that the audit procedures was not necessary. They phrased one of your experts as calling it the gold standard, and they don't necessarily have to follow the gold standard. They follow what is appropriate and required. Are you seeking to preclude them from raising that?
Again, Your Honor, and the audit comes up in another motion we're going to have today. I think it's MIL number 7 for ETT.
Right, but it
That's part of
came
it.
out
We
historically,
can
yeah.
bring it in, we can discuss it here. I think they improperly describe it as a gold standard. It is an industry standard. And so,
a different concept, but you understand, what I'm saying?
Exactly.
Are you asking them to waive their defense? This is really simplistic, as my question would be more so.
and so, let me see if I can be as precise as possible, Your Honor. They have not, they being ETT, nor Real Water, nor did I think Real Water would do it. I think ETT is trying to find a broad way without actually giving you or alluding to a single regulation, because they haven't done so. If you look at their opposition, there's no CFR mentioned, there's no statute mentioned, there's nothing mentioned there. And so there are these hypothetical regulations and statutes that's somewhere out there in the hither world. We don't know if we'll ever see them identified, because they haven't been identified in the opposition, and they weren't identified by their experts. So I guess what they're hypothesizing is coming here and saying, we don't know what the regulations are, we don't know what the statutes are, but somewhere there's a statute or a regulation that says we don't have to do this. Your Honor, that's certainly not allowed. And so, in terms of whatever regulations they think they can introduce without the benefit of a single expert report saying such, I don't think the court is obligated to delve that deep into hypotheticals.
Okay.
So my thought is, in terms of what Mr. Odou said, I believe he argued in Gallagher that because they never knew hydrazine was going to be introduced through this electrolysis process, they didn't have enough information to even test for it. That's what I think he's going to argue. And we can't prevent him from doing that.
Okay.
So I think that takes care of Mr. Odou's issue.
Should I
But
ask
Mr.
Mr.
Odou
Odou to
can't-
see if he has any other issues that he wants to draw? I'm just trying to get, the clarity, so you might as well.
Sure. I'd rather do it now, like you said, and prevent the problem or confusion later.
Thank you, Joul Odou for Real Water. That is correct. I think Mr. Parker and I are on the same page and have an agreement. And also, this goes to cross-examination of Dr. Gatnow. It sounds like they're not trying to change any cross-examination I've done for the entire case. So I don't believe there's an issue between plaintiffs and Real Water at this point.
Like I said, you all have the benefit, you already done a trial.
Absolutely, Your Honor.
I'm not a fly on the wall. I wasn't listening with the glass at the ear. I had my own cases, had my own things, and intentionally was making sure I stayed fully away from that because of my other cases. But, so that being said, if you all are on the same page, I'm gonna see if ET&T/Terrible Herbst has any specific questions, just so that we get everyone an opportunity to be heard and respond.
Thank you, Your Honor. I understand plaintiff's motion is to preclude us from arguing that there was some violation of a law or compliance with a specific law, but that interpretation is not exactly accurate. The reason we filed this opposition is because the plaintiffs are going to come in, as we understand, and argue that Terrible Herbst failed to comply with some industry standard or some regulation that would require Terrible Herbst to audit Real Water. And our position and reason for opposing this motion is to allow us to point out to the jury and to obtain this testimony from various experts that there is no such regulation or law that requires Terrible Herbst to go out and audit. So I don't think we should be precluded from arguing that. It certainly goes to the heart of plaintiff's punitive damages claim, and Terrible Herbst would be unduly prejudiced if we're not at least allowed to argue that there is an absence of a regulation, statute, or law that would require Terrible Herbst to do something that it didn't do in this case. And for that reason, we think the motion should be denied.
Okay, so I'm doing this a little bit out of order, as you all can appreciate, because we're trying to get clarity.
Of course, Your Honor.
So, counsel, you've heard Terrible Herbst's question, right? And their concern, without going specifically, are you seeking that if you all say that there's some regulation that they can't, for lack of a really nice legal way of saying that they can't call you on it?
Your Honor, if they have a regulation, statute, whatever, that they want to specifically use as a defense, I would have thought it would have been in this opposition given EDCR 220. It's not there, Your Honor. I don't know what, they want you, ETT's counsel would love for you to give them carte blanche on regulations and statutes that you don't see here. And so how do you even determine what statutes or regulations would be applicable, and how can we examine them if they put forward none in their opposition? And their opposition, Your Honor, is, well, how long? It is 9 pages long, including the certificate of service, and there's not one regulation identified, not one statute identified anywhere. None, zero. And so they cite cases that are inapplicable, and I just don't see how this opposition is even considered an opposition, Your Honor.
Counsel, what I understood is their statement was if plaintiff is saying that there's a regulation, that they can respond to say plaintiff has not presented any law or regulation that puts this duty upon X. Are you seeking in your motion to preclude them from saying that? So if it's asserted in argument that something does exist, that they can respond to said argument, whether the argument comes in as argument or whether the argument comes in as potential testimony or an objection to testimony, right, the plethora of ways that could possibly occur.
Okay. So, Your Honor, first, under the case law, and I'm going to answer the question, but I want to just put this out as a premise. The case law indicates that compliance does not negate a strict parties liability finding, number one. Now, if they're suggesting to this court that they'd like the opportunity to be able to defend themselves, the quintessential shield, by examining or cross-examining our witnesses on statutes or regulations that we bring up, certainly we would open the door to that. But what this motion is designed to do is prevent them from using that as a sword. A shield, one thing, that's the situation you just described, and that makes sense.
Okay. That's what I think counsel for.
And if that's the only thing counsel is saying, then I think we have reached some understanding. If they're trying to use it as a shield, as a sword, Your Honor, for which they have no expert reports or opinions, they shouldn't be able to use it in the form of argument. And based upon their opposition, they've not identified that sword. So, Your Honor, I think the motion should be granted consistent with that. In terms of what you said as a shield, that's fine. If we bring that up in our case in chief, a statute or a regulation that we believe imposes an obligation on ETT that they failed to comply with, then certainly they should be able to cross-examine our witness on that point.
And how about if they're contending that you all have rested your case in chief and you have not brought up any requirement, any statute or regulations that requires what you're saying they should have done in that type of context? Are you seeking to preclude them from bringing that point up? And I'm talking
That is
about
as
pure
a sword.
hypothetical.
That would be a sword, Your Honor.
Okay.
Yes, we are. And if they had such arguments, it should have been framed in or put within the framework of an expert report. Should have been in his opposition, which is not. So
I guess,
yes.
I'm sorry, I may not have been clear in my question. Let me go outside of this case and give it like a hypothetical, right? If it was a hypothetical automobile accident case, and if it was contended that if plaintiff in their case in chief in my hypothetical had said, well, in Nevada you can't turn right on red no matter what, which we know is not Nevada law, it's some other states, right?
Right.
Okay. And this car turned right on red. So in defense's case in chief and said hypothetical automobile incident, might want to say, well, you heard plaintiffs say this, but did they provide you any case law that supports that, or any rule or any statute that supports it?
Mhm.
So are you seeking them to preclude in my hypothetical right-hand turn to say your absence of presenting anything that supports a proposition that you're coming forward with, if you choose to come forward with it in this case?
Yeah, I think our case law prevents that. The case law we cited prevents that.
Okay.
Because it's not relevant in a strict parties liability case.
It's if you bring it up.
That's right. And you're right there. When you put the finer point on the cross-examination opportunity, if we bring that statute or regulation forward.
Or
I
contend
get-
there's one without citing to one. If
I
you
don't
were to
agree.
say Nevada law, go back to my right-hand turn,
Sure.
right? If you were to contend Nevada law precludes, no matter what circumstance, you can't make a right on red, okay? Ignore the fact that we know that's not Nevada law.
Right, of
okay?
course.
So then, in defense's case in chief, are you seeking them to preclude to say, well, you heard counsel argue that, but did they point you to any statute or rule?
Yeah, again, it would be
Or
irrelevant,
cross-
Charles. That's the problem.
Well, you would have
They-
brought it up to
if-
say that it's required, so you're saying they can't rebut your argument that it's required. That's where I was trying to really ask.
Yeah, again, Your Honor, if you look at the case law, the strict products liability case law, one of the fundamental tenets is that's not a defense. Everything is based upon the product itself. It takes all of this negligence, reasonableness of the conduct out of play.
I
And
understand
that's
my
why-
example was,
yeah.
in negligence context, this is a product's liability, was if I was trying to take something outside of product's liability just for a concept of somebody arguing something that it exists without doing any citation that it exists for the concept of letting somebody respond, not trying to expand product's liability, that there's a customer expectation test or anything like that. I'm not trying to
Right.
expand
I
anything
get it.
or change the negligence versus the product's liability. I just was trying to find some hypothetical concept if one side were to argue something that the other side, if you're seeking them to preclude, to say that may be a nice argument of counsel, but it doesn't have support in Nevada law.
It does not. And just to set the table, Your Honor, for this, because when you're not, if you're not saying the court's not experienced, but when a jury, and this is one of the reasons why we wanted to pre-instruct the jury, when you're not familiar with the concepts of strict products liability, your mind automatically goes to what would a reasonable person do? Enough people are familiar with tort law and negligence practices to
Right.
understand that. But the elements under strict liability is the defendant was either a manufacturer or distributor. We know that ETT was one of the other, or one of the other. The product was defective. We know the product was defective.
Is that the stipulation?
Number 3, the defect existed at the time the product left the defendant's possession. We know that.
Remember, currently AT&T takes a different position on that. The court's not making any affirmative ruling. That direct issue is not before this court. Go ahead, please.
That's right. The product was used in a manner that was reasonably foreseeable. We were drinking the water. They expected us to drink the water. The defect caused the plaintiff's injury. There's nothing in those 4 elements that deal with regulations, compliance, any of those things. It does not matter. And so when ETT wants to get up and parade or not parade, just argue hypothetical regulations or suggest because there's no regulation, we didn't have to comply with Nevada law, that's tantamount to jury nullification because that's what the law is.
I was saying that they were trying to argue that in a punitive damage type component. If you were trying to assert certain things that they would want to say, right,
That's right.
they didn't have the conscious disregard, all the different standards, right, under punitive damages. Okay, no, I appreciate it. You're
Yeah.
gonna get last word. Let me
Okay,
hear,
perfect.
let me make sure Real Water, have you now been fully addressed?
Yes, Your Honor, Joul Odou for Real Water, thank you.
Thank you. Counsel for Terrible Herbst, have you had an opportunity to fully address anything? If not, feel free to set forth your argument.
Thank you, Your Honor. Just to clarify, there's still punitive damages claims, so this is not necessarily addressed to the products liability claim. We're talking about punitive damages, and the plaintiffs are going to come in and say that Terrible Herbst acted in conscious disregard for the rights and safety of Mr. Hunwardsen, and they're going to have their expert come in and say that there was some violation of industry standards. Then certainly Terrible Herbst should be allowed to point out to the jury that there is no law, regulation, or any statute that plaintiffs point to that requires Terrible Herbst to go out and audit or inspect Real Water. That's certainly a huge defense in the punitive damages claim. So we can set aside the strict products liability claim because I agree with counsel. But here we're talking about an allegation that Terrible Herbst consciously disregarded the rights and safety of Mr. Hunwardsen. And we should certainly be entitled to point out the fact that there is no regulation that requires us to go perform this audit that the plaintiffs say that should have been performed, or some $200 test that should have been performed. There's no requirement, and simply arguing and pointing that out is relevant, highly relevant to the claim for punitive damages. We should not be precluded from arguing that.
Are you
We
saying
oppose this motion, not for the products liability.
Okay, counsel, I need a point of clarification. Are you saying cross-examination of a witness who would bring that up? Or are you saying if it comes up in some other
Your Honor,
context? Can you get a clarification of what you're talking about? Because if you're saying it affirmatively,
Sure.
then the court has to ask you what witness you have, as pointed out by Mr. Parker,
Not
right?
affirmatively. I would I'm sorry, not affirmatively, Your Honor. This would be a question for the plaintiff's experts. Anyone who comes in and criticizes Terrible Herbst, we should be entitled to cross-examine them and ask them to point to whatever regulation they're relying on that would require Terrible Herbst to perform some $200 test on water it doesn't even manufacture, or to go out and inspect Real Water's facilities.
Okay.
That's what I'm talking about.
Okay, no, I appreciate it. Thank you. You've had a full opportunity to be heard. Since I asked you a question in the middle of your argument, I just was making sure you had a full opportunity to be heard.
Oh, did I not address your question, Your Honor?
Oh, no, you did. I was just
Sorry.
making sure in answering my question, you didn't not set forth anything else you wanted to set forth.
No, thank you, Your Honor.
Okay, thank you. So counsel for plaintiff, your understanding, it's cross-examination, not an affirmative new witness. Do you want to?
Which is what you and I discussed, Your Honor, a little while ago in terms of the sword versus the shield.
Okay.
If we raise a federal statute or regulation, federal or state regulation or statute, then certainly they would be able to cross-examine our witness. But the admission that we just received on the record would have been helpful earlier on, that they have no witness who can affirmatively address any federal regulation or state statute dealing with this issue from a punitive NRS 42 perspective, Your Honor. And again, conscious disregard under 42.001 does not necessarily depend on the recitation of a federal statute or regulation, Your Honor. But certainly, if we open the door to a regulation, she's simply saying she had the opportunity to walk into it. And we understand that, but in my opinion, Your Honor, given the clear case law we have in Nevada, it does not negate the need to grant this motion and to make sure we keep out this whole risk-benefit test that ET&T inappropriately suggested in its opposition, Your Honor.
Okay. So, here's what the court's going to do. Document 655, plaintiff's motion eliminating number 16. With the clarity of what is today's, yes, I'll use the word landscape again, today's landscape, the court is going to grant it consistent with applicable law, including the Mapes case. In so doing, however, the court is not precluding cross-examination of issues that come up, or if somebody feels a door has been opened and he needed to bring it to the court outside the presence of the jury, and the court will address if there needs to be something further than standard cross-examination. I think that meets the needs. It's consistent with applicable case law. It is so ordered. That takes care of motion eliminate number 16. Moving on to document 669, motion eliminate number 6 to exclude Dr. Hutt's liability. Terrible Herbst, motion eliminate number 6 to have clarity, excuse me. To exclude Dr. Hutt's liability opinions regarding retailers and distributors other than Terrible Herbst. Once again, this is one of those ones that was done before there's been a whole bunch of rulings, so let me see what's left on it. We have opposition there too by plaintiffs, and we had, Real Water's joinder to Terrible Herbst, document 718, plaintiff's opposition 834, Terrible Herbst reply 922. Go ahead, counsel for Terrible Herbst, based on where we are today with all the rulings and the new way that this case is going forward with one cause of action. Let me know what is left in light of where we are today. Thank you so much.
Thank you, Your Honor. Valerie Rojas for Terrible Herbst. This motion is kind of goes along with our motion eliminating number 25, which Your Honor has up next on the list, but I'll address number 6 first.
Okay,
Number
that's fine.
6
Wait,
is
do
to
you want 6 and
preclude.
20? Sorry, counsel, do you want 6 and 25 combined then? The court's fine with that.
Yes, Your Honor. I think
Okay, so then we're doing,
I
just
think
so we have
that's a good
clarity
idea.
for my wonderful clerk and everybody, so we've got it right. So we're doing document 669, Terrible Herbst motion eliminating number 6, as well as document 633, Terrible Herbst motion eliminating 25, together. Go ahead, counsel.
Thank you, Your Honor. Dr. Hutt is the plaintiff's, call it standard of care expert, and she prepared a report in a prior case pertaining to a couple of retailers but did not address Terrible Herbst. That same report was then disclosed in the Hunwardsen case, and again, did not address Terrible Herbst. So as an initial matter, Terrible Herbst would ask that the court preclude Dr. Hutt from now adding to those opinions to include Terrible Herbst as part of her criticism of retailers or distributors. The second part is, and this is actually number 6, which the reason we wanted to preclude her testimony concerning other retailers because, number 1, they're no longer in it. In this case, any retailers or distributors such as UNFI or Costco, and therefore to render opinions on those retailers would be irrelevant, but it would also be prejudicial and unduly prejudicial to Terrible Herbst because we anticipate that plaintiffs would seek to transfer those opinions onto Terrible Herbst, and there is no law which would permit the plaintiffs to do that. If an expert is going to disclose some opinions, they need to be disclosed in the report so that the parties know what to expect. And absent that, they should not be permitted to amend those opinions at the time of trial. Dr. Hutt also didn't render opinions as to Terrible Herbst during her deposition. Now, granted, it was taken in the first case and everybody was allowed to participate, but if she was going to render any opinions as to Terrible Herbst, then she could have simply done so like the other experts plaintiffs supplemented reports for. But that was not done, and it still has not been done, and for those reasons, we would ask the court to preclude Dr. Hutt from rendering opinions as to Terrible Herbst in particular, because she did not do so, and then to preclude her from rendering opinions on other retailers who are not in this case, because that would be irrelevant. And with that, I'll submit, Your Honor.
Okay, so counsel, I need 2 points of clarification in light of other rulings and other things that have brought up. So subsumed within your request in this motion is to preclude anything going on about the audit issue that's been referenced. Is that correct?
Yes.
Okay. And then my next question, is it basically to preclude Dr. Hutt completely? Because what would she still be opining on?
I don't know what else she would be opining on, Your Honor.
So indirectly, it takes her out completely. Okay, no, thank you, I just wanted to, that's what I thought, but counsel for, oh, you know what, counsel before plaintiff, let me get Real Water. Real Water joined on number 6, so let me make sure they don't have a position.
Joul Odou for Real Water, nothing to add, Your Honor. Thank you.
Okay, and you did not have a position on 25, is that correct?
Correct, Your Honor.
Now go ahead, counsel plaintiff, thank you so much.
Good morning, Your Honor. This brings up the difference between generic experts and case-specific experts. So in this case, we have 17 actions consolidated for pretrial discovery purposes. So what the special master did is he said for a generic expert, and some examples of that, Dr. Najim, our hydrazine expert, Dr. Dooley, our hydrazine testing expert, Dr. Kosnev, the toxicologist, and Dr. Hutt are all generic experts. So they were deposed with regards to their generic opinions in the first case, and there's no further deposition allowed for them unless a defendant in one of the subsequent cases, this case or the other 17, files a motion for leave about something new and different that they need to ask. And we cited a little, can I have 10 please, Shane? So we were at the special master's hearing, and we were talking about the time period for discovery that would be needed in this case, this specific case. And so we were talking about the difference between case-specific and generic experts. And so Mr. Pepperman recites what the special master had previously said, that if they're previously deposed, they're not opposed again on the same opinions. Those are generic experts. And so we have some case-specific experts. In this case, the case-specific was Dr. Hudson, and he was redeposed again in this specific case. So we have Dr. Hutt, a generic expert. So we took the generic opinion that she submitted in Gallagher, and we just filed that in this case. We did the exact same thing for Dr. Najim, Dr. Dooley, and Dr. Kosnev, because they're all generic experts. So what they're really arguing is that you can't have a generic expert that says that all retailers should do third-party audits. That's the opinion in this case. And I'd like to get to her opinion. Can we have her opinion up here, Shane? Checked. So this is her opinion. and you've referred to it yourself, Your Honor, the gold
This
standard.
this is
the
page
retail-
9. Is this page 9 of your depo? I mean, page 9 of your house?
Shane, five.
Wait, hold on a second. Okay, thank you.
Sorry, Your Honor, I got a little bit ahead of myself here.
No worries.
Okay.
Wait, page, okay, go
Yeah,
ahead.
this is her testimony that we refer to as the gold standard. And that's in the off page 5, lines 8 through 9. And then the next one, Shane, this is Costco's policy. Costco, and this is evidence too, their written policy is they're a retailer, just like Real Water, Terrible Herbst. They don't sell as much Real Water as Terrible Herbst does, but this is their policy. Everybody has to have an annual food safety audit. And next one, we have evidence from other retailers. This is the Whole Foods guy, Mr. Brown. Do you think consideration should be done to do whole third-party audits? He's saying ideally every supplier should be audited. We got even more testimony. The standard for the supermarket industry is to do annual audits. So Safeway's doing it. He's talking about Albertsons, Stop and Shop, Food Lion, those second two I'm not that familiar with. Winn-Dixie, Publix. This is the Kroger's. This is the standard in the industry for retailers to do audits. So that's what Dr. Hutt is going to say. That let's get to her specific opinion, her generic opinion. Shane, I think that's 5. This is her expert report that was filed in both this case and filed in Gallagher case. And it's going to be filed in the next case. The standard within the retail industry is to require annual audits of all suppliers. So she talks about the standard, and then we go into Whole Foods a little bit, because Whole Foods and UNFI were the defendants in the first case. We talk about Costco, but just because we talk about specific suppliers in a generic report doesn't mean it's not generic. If you take a look clearly, that's a generic opinion about the standard for all suppliers. She talks about that, and then we get to her opinion at deposition when she was deposed. Can I have 6, Shane? This is generic stuff. This is where the standard was developed. Next one, Shane, 7. Talking about the standard. This is just the standard that's applicable to all retailers. It doesn't matter what their names are. Standard within the retail food industry is to require an audit. So those are the opinions that she gave previously, Your Honor. I believe they attended this deposition of the Gallagher case, but they did not ask the special master for leave to redepose her for any reason in this case, so she wasn't deposed again. But that's an appropriate generic opinion to give. And that's the same opinion that was offered, or we didn't call Dr. Gallagher, I don't think about it, because UNFI said that was the same opinion that was disclosed in the Gallagher case. So they're arguing basically that we can't do generic experts.
Can you go back to the special master hearing? Was there an order after that hearing? I saw that was Mr. Peppermint's comments, but
No,
was
he
there-
never came out with an order. We just all sat around and we decided what we're going to do with the generic and case-specific experts. And he made a comment that, well, we're not going to redepose generic experts, which everybody liked, because we did, in the first case, we did 24 expert depositions in 27 days, which was probably the most arduous task we had in the whole litigation so far. So we didn't want to have to depose Dr. Nash and Dr. Kosnin, and they had generic experts on their side too, Your Honor, so we didn't want to depose them. But in any event, when you have a generic expert, they don't have to say the word Terrible Herbst, or they don't have to say the word Speedy Mart, or they don't have to say the word Albertsons, I think, in an upcoming case. It's a generic opinion. You saw the opinion. So that's what Dr. Hutt's going to testify to, and there's no reason to prohibit it.
Okay, do you want to go to 25 specifically with regards to, is Dr. Hutt going to use the words
Terrible Herbst?
Terrible Herbst?
No, Your Honor. She's just going to give what I've indicated. She's not going to study the Terrible Herbst specific situation. We've given her the transcripts in case it comes up on cross-examination, but I'm not intending to have her say, oh, I looked at Terrible Herbst, and Terrible Herbst has 110 outlets.
That's on what, your square footage and your outlet
Right.
analysis?
She's not going to say anything about that.
I appreciate it, thank you so very much. Okay. Terrible Herbst, it's you get last word, it's your motion. I will tell you the court's gonna have one more question for you, and that one more question is gonna be, do you disagree with or agree with the presentation of the generic expert concept pursuant to the special master who is overseeing all of these cases for coordination purposes? I mean, I'm just trying to make sure everyone's on the same page that, yes, there was the generics. If someone's disputing that procedurally, I have to address that first. If not, I'll go straight to substance.
No, Your Honor, with respect,
Go ahead, please.
thank you. Valerie Rojas for Terrible Herbst. With respect to Your Honor's question, no. I don't disagree. I was at the special master hearing. I didn't find it in a transcript, but essentially we understood that if there was a generic expert, we would not be entitled to redepose him in this case unless there was good cause or some reason for doing so. And I think that a prime example would be Dr. Najam. Dr. Najam is plaintiff's expert who will render opinions on hydrazine. We understood we were not entitled to redepose Dr. Najam. He resubmitted the same report. It was not specific to any particular defendant, but just hydrazine in general. Now contrast that with Dr. Hudson, who provided a report in the prior case and also provided a specific report in the Hunwardsen case to comply with NRCP 16.1. He specifically addressed Terrible Herbst. Therefore, we did redepose Dr. Hudson without objection. But with respect to Dr. Hutt, he did not submit a supplemental report, and it was not specific to Terrible Herbst. The rules require that any opinions that are going to be incorporated or going to be offered at the time of trial be set forth in the report. That was not done here. The plaintiffs are trying to circumvent that failure to comply with Rule 16.1 by now saying that her opinions apply generally to all retailers all time. That's just not the case. If she was going to say that, she should have said that in her report, but did not do so. I don't think she should now be allowed to come in and change her opinions, and for that reason, we believe that she should be excluded from testifying. Did I answer your question, Your Honor?
I'm going to have a follow-up because it was in part. What I was trying to get an understanding is, it seems you all agree there could be generic experts. Is that correct?
Yeah, and Dr. Najam would be one of them, right?
Okay. Okay.
Those types of experts.
So what this court's trying to have a better understanding based on your statements and your clarifications is, are you saying because Dr. Hutt actually used certain names of certain parties that were in the Gallagher case and did not specifically use your client's name, that changed her status from a generic expert to a specific expert, or are you contending something different? That's where the court's got a little bit lacking clarity, because it seemed to me you're agreeing that she was a generic expert,
No.
but then it seems like you're saying because...
No, I would not agree she's a generic expert. I think Dr. Najam certainly is, but when you're going to criticize, and granted at the time there was still the negligence claim, so the anticipation was she was going to address standard of care issues, but she's also certainly going to be relevant to the punitive damages claim, right? Whether Terrible Herbst consciously disregarded some standard, some regulation that they failed to comply with. So she is not a generic expert. Dr. Hudson was not a generic expert.
Okay, we're not there
and that's
yet.
why he also...
Yeah, well, let's focus on the current one, so people don't have a lack of clarity when you're saying two different names that sound somewhat similar, who actually is the subject of this motion. So Dr. Catherine Hutt. On what
Catherine
basis
Hutt
are you saying she is not, this is why I need the point of clarification. Are you saying the designation wasn't a generic expert, or are you saying you don't view her opinions as being of a generic type context? Or some
The disclosure was not generic. It addressed the fact that Costco specifically undertook to audit real water and what that audit meant, and her criticisms of Costco as a result of the first audit at least. She also addressed specifically UNFI and their food safety program. And I don't think she addressed Whole Foods, but she specifically addressed certain defendants in her report. Given that, she is not a generic expert.
Okay, and your definition of a generic expert, that's what I'm trying to get to the heart of, is coming from what? The reason why I was asking, like I said, I looked through this entire case, couldn't find an order. I looked through my other cases just to see if it was maybe filed in one of my other ones, didn't find an order. So what I'm trying to get a better, see if everyone's on the same page, or maybe you have a disagreement that this court needs to resolve, is, are you saying there was some specific criteria of how someone needed to be designated in order to fall within the category of a generic versus a specific expert, as Special Master Hale said, or? If
No,
not-
and I think maybe that's what the problem is here. I mean, my understanding and plaintiff's understanding of what a generic expert is clearly not. Special Master Hale did not, from what I recall, specifically define what that.
Okay, but Dr.
Eric,
Catherine
to
Hutt
me-
was disclosed in Hunwardsen, right? And her report was filed in Hunwardsen, correct? And I use the term filed, whether you all are, yours a repository or disclosed, right?
Correct, and that was, like I said, the same report previously without any specification that it would apply to Terrible Herbst or any other. At the time, Costco was still in the case, so we anticipated it was applicable to Costco in their attempts to audit real water.
Was there anything in the
But-
disclosure that said it was only as to certain parties to the case and not all parties to the case?
In her report or in the, just the pleading?
Well, in the
I don't know the answer.
Okay, I understand in her report, she makes some references to distributors, which end up being Whole Foods. She makes some statements regarding Costco, but what I'm trying to get through is, right, looking at from the procedural standpoint and NRCP 16.1 standpoint. Does it?
Yeah, I don't
maybe
recall
someone's
there
gonna pull up
being
her
any
description
mention.
of an expert in this case, maybe that might be helpful, but are you contending that somehow there was something put in the description that led your client to assert that it wouldn't be against you all?
Your Honor, I can't just recall that description right
Okay,
now. I mean, usually it's pretty generic, so that's why I look to the report.
right, but our NRCP disclosure requirements, particularly, well, always, even before Fiesta Palms and the changes in 2019, but even more so since the 2019 amendments, as stated in a lot of the commentary, including those specific to 16.1 disclosures, cannot be a generic one-sentencer. So I'm gonna have to ask a question of plaintiffs, and then counsel for Terrible Herbst, you're gonna get the last word. First off, A, it'd be helpful to this court if, I can go back looking through everything to find your disclosure, or B, if somebody's got it handy, popping it up on the screen. Mr. Odou is about to mention something. I'm gonna let him speak, since Real Water, since Terrible Herbst, you'll get last word, and Real Water, you had a joined, or at least one of them. Go ahead, please.
Your Honor, document 210 is CMO number 1. The court was inquiring where to find it. It's document number 210,
Thank you, let me go back.
paragraph, page 3, lines 20 through 24, talks about if an expert is disclosed in one case and somebody has an objection, the parties are to meet and confer. I'm completely paraphrasing.
But that doesn't thank you very much. I'm gonna go back to that specifically. I looked at that, but I didn't.
On page 3, lines
I
20
appreciate
through 24, talks about experts, and then there's another section that talks about if a lay witness is deposed, or any witness is deposed,
Okay.
that can be applied in other cases. The court's inquired about that a couple of times, so we went back and found it.
No, I appreciate it. Thank you so very much. So let's go back to that. Okay, so,
It was filed on January 24, 2023.
I have it, I appreciate it. I'm on page 3 under Roman numeral 1, discovery scheduling order. And I'm looking through suggested dates. Trial issues, discovery motions. deposition protocol does set forth, starting on page 6, Roman numeral 4, is that what you're referencing, counsel?
Yes, and then on page 3, under the rebuttal disclosure deadline, there's an explanation starting on line 20 on page 3. Okay,
Okay.
general, like first rather than generic.
When I read this the first time, I saw those general statements. It's trial management. It's happened way before endoscopy cases, but endoscopy is probably one of the ones and happens in CD all the time. Large cases, opioid, others. But what I didn't see specifically in here, which part of the question the court was asking, is whether, I'm trying to address the concern raised by Terrible Herbst about whether or not, if there is, only question is in one, but I didn't see that one. Okay.
On page 5 of our motion in limine number 6, if your honor is looking for the disclosure language.
Right, I'm gonna.
I have the full quote I can give you if you'd like.
Yeah, I'm gonna go back to that in just one quick second. Thank you so very much. Let me just finish reviewing the reference that Mr. Odou made, and then we'll go to
Sorry.
yours, and then. Right, and this court's recollection, I mean, originally Hunwardsen was supposed to be the first case to go to trial, because this was set, right, until you had your preferential, which is why Gallagher popped in front of it, correct?
Yeah.
Yeah.
Okay, that's this court's, once again, that's this court's recollection, so everything that was addressed in this hearing was kind of with the context that, well,
Not really, Your
Hunwardsen
Honor.
/ Gallagher was gonna be first or not?
Not really, Your Honor, we just kind of addressed the fact that we had,
A whole bunch of cases?
right,
Okay. Okay. Where I was going is, everyone had notice of this case. This is not a later filed case.
Clearly.
Even though there is provisions about later filed cases being applied to this, I'm just, when I say this, document 210 was at the time the Hunwardsen case as a 2021 case, and one of the first cases, because this court's understanding is this court was the first court to start setting all these trials, and our initial scheduling was trying to take into account other cases would be tried in between the dates and times and where you all were, but Hunwardsen was always on the horizon of this. It wasn't a new case. Okay, is that correct, everybody?
That's correct.
Is that correct, Ms. Rojas, as well?
Yeah.
We get everyone's
I
name.
believe so, yes.
Yeah, okay. So now let's go, Ms. Rojas, you want me to go back to
I was going to quote from the disclosure that Your Honor was asking about. We did include it on page 5 of motion in limine number 6, but I have the full description.
One quick second, I'm gonna go to. You understand that the court's evaluating the, basically, equity component in the one sense, is the reason why I'm trying to get clarity on dates and understandings, because I don't see any violation of NRCP 16.1, so I'm trying to see if there's. Let's go back to 669. Okay, counsel, what page did you want me to look at on page 6, on document 669, your motion? Go ahead, please.
On page 5, in which the plaintiffs describe Dr. Hutt's testimony, keeping in mind that at this point I believe both Costco and UNFI were still in the case.
Right, but how are you saying
It's-
that doesn't include your client? That's,
Because there's no opinion specific to my client, and there's no generic testimony in her opinions. It's about Costco. It's about UNFI. If somebody's going to criticize a defendant, they should be obligated to specify what the criticism is of that defendant. Not all retailers are the same. We certainly aren't Costco or even Whole Foods.
did
Not all
Terrible Herbst-
retailers are similarly situated.
Oh, I'm sorry, I thought you were finished. Let me let you finish. Please, go ahead.
Not all retailers are similarly situated, and according to the plaintiff's disclosure, Dr. Hutt is a quality assurance expert and will offer testimony opinions consistent with her attached report. Dr. Hutt's testimony and opinions may include, but are not limited to, matters regarding her findings and conclusions regarding food safety regulation requirements and industry standard of care relative to the manufacturing of real water, standard of care opinions related to annual food safety audits, in caps, her knowledge of the facts and circumstances concerning the subject of the litigation, her investigation and opinions in an expert capacity, and all matters related thereto, end quote. The next paragraph goes on to reserve her rights to offer rebuttal opinion.
Okay.
That
So you're saying because her report only mentions Costco and the distributor for Whole Foods, that she would not be able to opine for industry standard of care as it relates to other members of the said industry?
correct, Your Honor. And this would be akin, if I can draw the analogy, in a medical malpractice case where a number of cardiologists were sued. They're all they may all be cardiologists, but an expert can't certainly render a generic opinion as to two and then superimpose that opinion onto the third cardiologist. And that's exactly what the plaintiffs are trying to do here.
But doesn't
If
the court
Dr.
have
Hutt
to-
had some opinion,
Sorry, go ahead, please.
if Dr. Hutt had some opinion specific to Terrible Herbst, then she should have disclosed that in a report in the Hunwardsen case. And because she didn't do that, Your Honor, she should be excluded from testifying.
Okay. I appreciate it. Has everyone had a full opportunity to be heard? Counsel for, it was your motion, Counsel for Terrible Herbst, you had a full opportunity to be heard?
Yes, Your Honor, thank you.
Counsel for Real Water, you had a full opportunity to be heard on both 6 and 25?
Joul Odou for real water, yes, Your Honor.
Counsel for Plaintiffs, you had a full opportunity to be heard?
Yes, Your Honor.
Okay. They're both denied, and here's the reason why. Well, I appreciate the example of doctors. Remember, that is a negligence case, has specific case law here in the state of Nevada, and it is distinct. Here, here's what the court has to look at. You not only have the Rule 16.1 obligations, but here, as pointed out, document 210, the CMO gives the right of a party, but it puts the affirmative obligation on the party who wishes additional deposition testimony or additional information to request said additional deposition. It does not say that the disclosure itself has to encompass all cases, all potential parties in each and every case. And so this court can't look at this as a standard single case where it's, quote, a new opinion. I'm going to get to the new opinion concept in just a quick second. But it has to look at what actually is a case such as this one where you have coordinated discovery. You do have the CMO. While the CMO doesn't specifically articulate if you have certain parties in certain cases, then you have to do A, and if these parties not in this case, you have to do B. It does have enough of the general language to put any party on notice in any of these coordinated cases, because it even talks about subsequent cases where this is definitely not a subsequent case because this is a 2021 case and it definitely existed. It's named specifically in the CMO. So what I have to look at is what were the rules for this case. The case management order was entered into under the coordinated cases, and so that gave anyone an opportunity that if any witness was designated in the, quote, generic type context, disclosed in the generic type context, then any party who wanted something with regards to that individual would need to do certain things. I can hear that Terrible Herbst didn't think they needed to or chose not to, but I don't see anything that therefore would require preclusion of the expert, particularly since here when you read the expert designation itself talks about industry standards. It talks about the findings and conclusion regarding food safety regulation requirements and industry standard of care in the manufacture of real water, standard of care opinions related to annual food safety audits, etc. That in and of itself, under Nevada case law, gives enough notice under the 16.1 requirements that she is potential witness for any party who is in the Hunwardsen case. Look at it combined in the CMO. If somebody felt that her opinions were either not applicable or needed further fleshing out or somehow could benefit them in Hunwardsen, they had the opportunity under the CMO to seek further deposition, to seek any issues about whether or not, at the discovery time, whether or not she should or should not be a part of this case. So in that regard, since Dr. Hutt falls within the CMO proper designation protocol, since it falls within 16.1, the court needs to deny motion eliminate number 6, but I'm gonna give a small carve out, which realistically is gonna apply more to number 25, but since I'm gonna ask, and I'm also gonna deny motion eliminate 25, for the same reasons, motion eliminate number 6 being document 669, motion eliminate number 25 being 633. The one carve out is under the standard rules, and I understood from counsel for plaintiff's presentation this is not going to occur, but I'll just make sure it's in a ruling as well, is that she would not be able for the first time at trial to offer any new opinion specific to Terrible Herbst that has not otherwise been able to be fleshed out. Now, generalized opinions which apply to Terrible Herbst is not the carve-out that the court's saying. That is allowed under the CMO and Rule 16.1. But, for example, if she were to come on the stand and say, I now have this opinion on what Terrible Herbst specifically should have done this testing on this date, that date, or whatever date, okay? She can do it in the generalized context, but she can't say something specific to Terrible Herbst that's not otherwise been put on notice in her deposition or her report consistent with Fiesta Palms, because it was 16.1, consistent with your CMO. It is so ordered, and that's both for 6 and 25, which means with regards to the 6, I do need to say the exclusion is denied on 6, and the joinder is denied as well, consistent with the court's ruling. With regards to 25, there was just a motion, so that one is denied, consistent with the court's ruling as set forth here. And does anyone need any clarification of the distinction of what the court was saying about a new opinion versus a generic opinion? Counsel for Terrible Herbst, do you need any clarification?
No, I understand that, Your Honor. Thank you.
Counsel for Joul Odou, do you need any clarification?
Joul Odou for Real Water, no, Your Honor, thank you very much.
Counsels for plaintiffs?
No, Your Honor.
Okay, appreciate it. Let's move forward. Moving forward to document 673, Terrible Herbst motion eliminating number 16, to exclude references to prior, quote, outbreaks with a joinder by Real Water 727, plaintiff's opposition 856, and Real Water, excuse me, and Terrible Herbst reply 957. Go ahead, counsel for Terrible Herbst.
I think we do this one?
Yeah.
I think we did this one, Your Honor.
I thought so too, but it's showing up on my,
Yeah, the next one I showed is 473.
okay, one second, there was just a little bit of clarification, okay, that just might have been, hold on one second. Okay, so ignore what the court just said because it's on my listing, but I think that was an error. There might have just been, okay, here we go. So, that means we are, it's 5 and 6, okay. So the 7th one we have on for today should be document 473, not 673, my apologies, excuse me, which is Terrible Herbst and Costco's, but Costco's is moot, so I said I'm only hearing this obviously on behalf of Terrible Herbst. Motion eliminating number 1 to exclude evidence and references to the stiff admission of liability by the Real Water defendants. We knew this one was coming up. Okay. Counsel, I appreciate this was done before the court's getting the STIP. Now I have a STIP. Now there's a notice of entry of order, so there's a court order on the STIP. Counsel for, I see counsel for Real Water standing up, so.
Yes, Your Honor, Joul Odou for Real Water, just very briefly, if ATT wants to put this over and have it heard with the summary judgment motion, they just filed a brief on the summary judgment motion. I have no objection if we put this one over and hear it on Wednesday, or I'm prepared to go forward now, whatever is up to the court. But I read their brief and it really goes hand in hand with their summary judgment motion. So I know the court hasn't seen it. I'm just giving the court that.
Yeah, you can appreciate, you know where I've been.
Yeah.
And I don't have people in the, home front going doing other things. It's, right.
So I have no objection putting this over to give the court time to review the brief and hearing both together on Wednesday.
Let me ask Terrible Herbst, since it's your motion, does that make more sense to you to put it over for Wednesday, or you want it today?
Thank you, Your Honor. Yes, I was actually going to make the same suggestion. I didn't see our motion come through yet, but it is being filed, so I do think it makes sense to put this one over. And I also had a different motion. I'll let the court finish with this, but I thought we were on real water 1 on my list. But if we could put this one over, I think that makes more sense.
Okay, Counselor Plaintiffs, any objections from you all?
No, Your Honor.
You're stealing somebody's thunder.
I was always, exactly, he's doing this all.
Mr. Parker, on behalf of Plaintiff Socia, is there any objection?
I'm prepared, I'm fine, Your Honor. Either way, I was excited about it, but I'm excited about all the arguments, so.
Be excited.
I hold over till Wednesday.
Stay tuned till Wednesday, is that
That's
okay?
it.
Okay.
That's okay, Your Honor.
Okay, so let's get a clarification, since the court had inadvertently said 673 or 473. So here's where the court